Welcome, everybody, to our industry update this month. I'm Jill Cox with Heritage Title. We're so glad that you joined us. We're super excited for our guests today. This is a repeat guest on our industry updates. Paul Bondy is an E&O Insurance Specialist. That's what he does. And when he was on a year or so ago, he offered so much great information. There's just so many complicated nuances to E&O coverages. And I think we all learned a tremendous amount about what coverages, what we're really protected for as brokers and what we're not covered for, and what to do as we make transitions, maybe from brokerage to brokerage, or if we get out of the business or retire or whatever. So we're just so thankful, Paul, for your time today. And we're looking forward to learning a lot. So with that, I'll go ahead and turn it over to you, and we'll let you get things going.
Appreciate it. Thanks a lot. Welcome, everybody. Jill, could you put up my presentation that I emailed to you when you get a sec?
Hasn't popped through just yet, but we'll keep.
So my presentation today really something I called Scared Straight. And I sort of talk you through the things, the most common lawsuits that I see in real estate E&O, the things that are most likely to get you sued, things that are sort of no-nos that you really shouldn't be doing, some things I've seen result in a claim that I want you to be aware of, and some things to know about coverage and what you have, should have, can have, whether you're on an individual policy or like what I do, which is group coverage, which covers the entire entity. But I wanted to start out with a couple of stats. So in 2019, my program, where I insure about 1,000 real estate brokerages around the country, we had 212 claims. In 2020, we had 414 claims. 2021, we had over 800 claims. In 2022, we had over 1,000. And this year, we're on pace to eclipse that. So that's what's happening in real estate E&O. As the prices go up, as you're selling a house in 12 hours with no contingencies and 30 offers, things are going wrong. Things are happening very quickly. So mistakes get made, or things don't get disclosed, or you don't have time to research certain things, or people are backing out on deals, multiple offer situations. It's way more complicated now than it was, or I shouldn't say it's more complicated, but the environment creates more incidents of claims than it used to. At least that's what I'm seeing. Damian, attorney, can probably chime in on that, but that's what I see. So my goal is to not put you in a position to win your lawsuit. My goal is to.
Hey, Paul, do you want to share your screen and pull your presentation up? You could do it from yours too.
I can't share
because he can't from his iPad. I have it.
So. My apologies. We got it. We'll get that up. I'm sorry. Go ahead.
So the goal is not to make you win your claim if you get sued, it's to not get sued. Our justice system is not set up to be just. It's set up that good attorneys win, and it's easier to settle claims sometimes than fight them, even if you're right. So you just trust me when I say you don't want to get pulled into a lawsuit, even if you are 100% right. It's
a lot of the people on the call, Paul, have always heard me say it's not about whether you win or lose. I don't want to play.
Right. Yeah. That sums it up nicely. So the first thing I want to do, Jill, there's a reporting advisory down 13 slides in. First, I want to go over what you should be reporting as an E&O claim, whether it's through me or whoever writes your E&O. It's down on page 13. It says reporting advisory. Yeah. So I think a lot of people are confused about what they're supposed to turn in as a claim to the E&O carrier. And here's what you should be reporting. Actual claims, obviously, demands, threats of a lawsuit, complaints brought through the real estate commission, through DORA or some other regulatory body, or things that you reasonably believe a claim is going to happen. If somebody calls you and says the house you sold me is on city sewer and you put it was on septic, but you told me in the listing it was on city sewer, you're going to get sued. You are going to dig that line out to the street. Call your E&O provider. If the square footage was wrong and somebody calls you about it, call your E&O provider. If somebody says, that a fair housing discrimination claim is going to happen, call your E&O provider. You don't need to receive an actual lawsuit to call your E&O. That is not what triggers your coverage. And by not reporting it to your insurance, you jeopardize your coverage in the event that a claim comes in down the road. The carrier could say, you prejudice the outcome of this claim by not giving us early notification of what was going on so that we could mitigate it. And so we never want to put you in that position. So my view is over-report, don't under-report. If you ever wonder if you should report it, call your E&O insurance broker. Good advice, Damian?
Good advice. I mean, there's a whole bunch we could talk about whether it's prejudiced or not and trying to get coverage, but it's easier to just report it and not have to worry about it.
Right, I agree. All right.
Is it worth mentioning, Damian, kind of the flip side of that, where I hear you often say, people just say, oh, just report it to E&O, just report it to E&O.
Yeah. I mean, I'll tell you, that's one thing that I hear a lot is that, and Paul, I don't know, you probably don't get this, but there's a lot of brokers out there that think E&O is a checkbook that, if you make a mistake, you go call up E&O and say, hey guys, I need you to send a check over to my client for $10,000 because I made a mistake. That's not the way E&O works. E&O's job, I got two insurance people on here, so I'm going to say this and they're going to not be like me, but you know what insurance is for? Insurance is, their job is to take premiums and deny claims. That's what their job is. That's how their business model works. I'm sorry, but that's what it is. And, so keep that in mind that, they're going to want to defend a claim. They're going to want to evaluate it. They're going to say, wait a minute, who else is responsible? Did the buyer sign the contract? Does that mean that they're responsible? Did the seller sign the contract? Did they have an inspection? Is there another broker that we can blame? So, keep in mind that, insurance is not a blank check, and it's painful to go through that process, even though if you got to report it. But, you're probably going to end up with an unhappy client out of it once it happens, because they're not going to like the pain that goes with going through the E&O process. So go on, Paul. I'm sorry.
Yeah, I mean, the flip side to that, so if you wonder if you should report it, to me, at least put it on the insurance agent who's writing your coverage. And if they say you don't have to report it, then you have this buffer. I carry E&O insurance. If I make the mistake, okay, there's still coverage. I have an E&O policy. So I can tell you, no, that's not something you need to report because somebody wanted purple shutters and you didn't want to paint it for them. And it's a $600 lawsuit and you don't want your E&O to go up. And then that turns into something else that you didn't disclose in the transaction. And now that $600 paint job is a $15,000 lawsuit. I had one claim where somebody had a $1,500 roof repair, and instead of reporting it to E&O, they decided to hire a contractor to fix that roof. And that roof wound up being shoddily repaired by a relative of the realtor who did the repair. It leaked, sparked a fire, burned down the house. Now the $1,500 roof repair was a full home replacement claim, which got denied because it was never reported to the E&O originally. So, leave it to the insurance agent to look 10 miles down the road and say, you do or don't have to report it. And at least that's my E&O and not your risk of not having coverage. That's what I think.
Or let the adjuster make that decision. Sometimes the adjuster may not mind if you want to try to do that, but let it be their decision, not yours.
Yeah, I agree. All right, Jill, if you could pop back up to the first page of the slide. Sorry to do the work there. So these are the most common claims that I'm seeing right now. Always fair to advise previous water damage. Sewer septic claims made up 11% of all claims last year. That was where you told, so that wasn't 2 tanks in the backyard or faulty sewer septic. That was, the listing said it was on city sewer, but it was really on septic. That was 11% of all E&O claims. That's 100% preventable. So before you go to the table on any contract, you should make sure you have corroborated through utility bills, or Damian, you can chime in, however Colorado verifies, but you should make sure that not what the seller told you, not what the city says it is, but through utility bills, Would you corroborate that, Damian?
Yeah, I don't mind that. If nothing else, get something in writing from your client that says, yes, it is on sewer. Just so that you have proof that you were literally taking what the seller told you and putting it in the MLS, because a lot of, at the end of the day, we all know that realtors have E&O insurance, and the plaintiff's bar says, hey, why just go after the seller when we have a pot of gold here called E&O insurance? Let's go ahead and name them too. So you guys have heard, I don't like investigating because that's not our duty in Colorado to investigate things, but on certain issues, it's worth at least having a conversation when it's questionable about whether or not it's on sewer or septic, to make sure that you maybe take that one little extra step.
Okay. HOA assessments. I think, Damian, didn't we have one just a few days ago? Wasn't there an HOA assessment issue?
Yeah, go on.
Okay. So these are really common, where somebody wants to buy a rental property and the HOA changed the bylaws and said you can't rent properties there anymore, or there's a special assessment for heavy snowfall from the wintertime that wasn't addressed or mentioned. So those are probably the top three most common claims that I'm seeing. And some other things to round that out are, the home is not permitted properly. Somebody did some upgrades. It was listed as a 4-bedroom, but it's really only permitted as a 3-bedroom home. I'm not sure exactly what you can do about that to prevent those claims, but I want you guys to be aware of what's causing the lawsuits. Doing repairs.
Real quick, Paul, somebody pointed out that that's why we have an SPD, is because, that's a way for us to have the representations from the seller, which is what we do have in Colorado. That's a good point, Daniel, that so we do have some collaboration from the seller instead of it just being our representations. But go on. Sorry.
Jill, could you pop to the next slide, please? Bodily injury, property damage. You're showing a property, somebody falls downstairs. I had one in Pennsylvania where it was a vacant property where a little kid went running through and fell down and broke his nose on the wood floor. Somebody gets bitten by a dog. Somebody was staging a home and took the doors off a hinge, and the door, they thought it would look good for staging, and it wound up falling over onto an elderly woman and broke her shoulder. I see all kinds of crazy things. Showing a property, you leave the sink on and it floods. I had one who left the gas on and somebody went in, lit a cigarette, and the house blew up. So anyway, those are pretty common claims. Obviously, escrow, somebody wants their money back. They don't want to follow through on the transaction. Solar panels becoming more and more common. They're very expensive. There's definitely confusion with the sellers on what needs to be done to either convey the solar panels or to remove and bring them with them. And I've seen a few claims from this. I don't know a lot about it. I would say if you are involved in a transaction that has solar panels, talk to your broker and ask them what you should be doing, what questions you should be asking if the property has solar panels. Wire fraud, and that is a claim where you have your email hacked or you click on an email that you shouldn't have clicked on. The bad guy then gets access to your email, finds out about a closing. Then they contact your client posing as you, telling your client to wire funds. Your client thinks it's real and they do. That's called third-party wire fraud. So if anybody out there does not have cyber liability, this is a separate coverage from E&O. I encourage you to consider it and look for a market for cyber liability for that specific exposure. There's also some cyber claims surrounding putting up pictures in listings or your website that you weren't authorized to use, and that's fairly common as well. Another thing I'm seeing is people getting sued for putting their team name in the MLS. I don't know if Colorado is any different, but in other states, if you don't put the specific license and name of the agent who's licensed with the state or broker licensed with the state in the MLS, you can get in trouble for that. You can't just put the Paul Bondy team. I have to put the name of the actual licensed broker. Is that the same in Colorado, Damian?
Not quite as severe. We definitely have team name rules that say that you have to have your brokerage firm on all advertisements, but they actually do allow you to advertise a team. so long as the brokerage firm can identify all the brokers that are in the team.
Okay. Next slide. Could pop down to slide 3. Thank you. Okay, these are the things that are most likely to get you sued, not the things that I'm seeing the most claims from, but the things that if you do on a per transaction basis, that are most likely to lead to a lawsuit. Damian, you probably remember this slide from last year, because number one on the list is selling to or for an attorney. That is the number one thing that will predict whether or not you will be sued in the transaction.
I love that.
So it doesn't mean don't sell to them or for them, but just be very cautious and careful that they understand the law better than you do.
And just so you know, that's not a fair housing violation. Attorneys are not a protected class. So feel free to discriminate against lawyers all you want, and feel free to tell lawyers, I'm sorry, I don't take lawyers as clients, because it may be a way to mitigate risk.
Dual agency, intermediary, transaction brokerage, whatever Colorado calls it, when you collect commission on both sides of a transaction, is always risky, because it's much easier to say that there was a conflict of interest or there was something that wasn't disclosed. You just wanted to get your 5.5%, 6% commission, whatever it is. You didn't ask somebody else to put an escalation clause in their contract because you wanted your own office to keep the contract. So you had, your buyer put one in and they got it. Anyway, I see a lot of those claims, and they're pretty expensive claims and hard to defend. Agents giving out loans or doing wholesaling, really, I'm against it entirely. I don't know, your feeling on it.
When you say wholesaling, also fix and flipping, or are you going to talk about that one?
That's separate.
Okay.
I'm getting a lot of claims for people that state when they do renovations that it's fully gutted, completely renovated. You don't want to use words like that. Those are incriminatory words. There are going to be parts of every house probably that you didn't renovate. So you don't want to say something like that. You want to make sure you disclaim the things that you've upgraded and renovated, and not try to be more vague about it, because you will be held to account. Okay, next slide. Almost done, Jill.
Sorry, just takes a few clicks.
Agent owned, which includes the fix and flips. So my biggest lawsuits that I see are for flips, are for when you renovated a property, and inherent in the flipping process is that your goal is to make money on that transaction. You are trying to buy it for less than you sell it for. And it's so easy for somebody to say, you knew that roof was getting old and had to be replaced, but you would have lost money on your flip, so you didn't replace it. You knew that AC had to be replaced. What do you mean you didn't know the pipes had to be replaced? You had it torn down to the studs in the kitchen. You saw all the pipes. You saw all the wiring. How are you saying you didn't know about that? It's so easy to allege that there were things where you cut corners on a flip because you wanted to make a profit on that flip. Doesn't mean it has to be true. It means it's easy to say. And when it's easy to say, those create some of the largest lawsuits. The biggest program lawsuit that I had was a woman who sold a flipped property to her maid of honor at her wedding. And it was like an 183-page counts against her of all the things in the house that she decided not to upgrade. So just be really careful. I would always recommend having your broker oversee any agent-owned or flipped properties, absolutely, at a bare minimum. And the last one is estate sales, because you're involving death and family and money in the same transaction. And I get claims where there's 5 members of the family, one person's the executor, the other 4 kids don't agree on selling the property, they want to keep it, they create a lawsuit. Again, it doesn't matter right or wrong, it doesn't matter if the law says you can do this, you can't. I see a lot of lawsuits from members of the family who are not involved with the realtor, then coming back saying, I have a problem with this. You didn't sell it for enough money. I don't want to sell it, whatever it is. In addition to that, usually you have out of state or out of area people who are the kids selling a house that they never lived in. The mother or father lived in the house. So when they're disclosing, they're missing a lot of things that they just didn't know about the property. So that can cause a lot of lawsuits as well. Now, hopefully I've scared everybody sufficiently at this point.
Oh, I'm sure there's more to come that'll scare them even more.
Yeah. So let me get into a little bit. If everybody has questions, let me know if they're chiming in. I'll stop.
Paul, there were a few questions that came up, the Q&A. Can I read those to you?
Yeah,
Is this a good time?
please.
Okay.
Yep.
So Teresa asked, do you get claims for inspectors that damage items during inspection? Is this a covered item?
I've never had a claim for that.
I think this goes to lockbox, and maybe you should talk about lockbox coverage and property damage and that kind of thing. Ultimately, the inspector is liable, period. But go on about lockbox coverage.
Yeah, well, the only way I could see the E&O get involved is if they say that you chose a substandard inspector, you have some special relationship where there's a kickback with them, and you didn't give them a list of different inspectors that they could choose from. You said to use this one, and they actually lost their license a year ago. If you made some error in the process of getting them to that inspector, I could see the E&O responding. Otherwise, I can't see the E&O responding to that claim. Property damage, they may say that you didn't properly supervise the property that was in your care, custody, or control. And in that case, a good E&O policy that has property damage coverage would pick up coverage for that if it's alleged that it was your error that caused that property damage. So that'll get me into the property damage coverage on. So all E&O policies are not created equal. It is not a commodity product like your auto insurance or general liability or work comp, which are very commoditized. E&O is a very distinct universe of policies that are offered out there that have vastly different coverage. So I'm just going to read from the state website. This is the RICE program for those of you that have the individual coverage. Some of the things or limitations of the coverage that you have that you might not even be aware of. So on the lockbox, you do have coverage for property damage, and it's $100,000 limit on the state program. You don't have coverage for lockbox when it's a bodily injury claim. So if you're using a lockbox and somebody falls down the stairs or gets bitten by a dog, you don't have coverage under the individual policy for that. If you have mold in the house and you need to remediate it, that property damage is not covered under individual policy. If you're selling a property that you flip, that is not covered under an individual property. If you sell property that you developed or constructed or your spouse did, and your spouse is not the sole owner of it, you don't have coverage for that. And those are things you can't get coverage for. And then there's a whole bunch of things that you need to remember when you go, if you're going to buy individual coverage, there are endorsements that you can buy. So if you're doing things like property management or selling in another state, you can buy endorsement to cover that. The bodily injury and property damage I was mentioning with the lockbox, if you want bodily injury from a lockbox, you can buy an endorsement for contingent bodily injury property damage that gives you $10,000 worth of coverage for a claim like that. And it costs you $30 through the Rice program or through the Williams program. So anyway, if you want to sell in another state, that costs you a conformity endorsement. You have to buy that. If you want to do property management, you have to buy that endorsement.
You mentioned construction development, but what about, I mean, I hear things like business brokerage or, there's others that come up, the agent owned you covered that there may or may not be coverage for it. Talk about business brokerage or some of those others too.
Okay. So business brokering has two components. One is a claim that involves the real estate portion of a business opportunity, which would be the land or the lease or the structure of the lease. And sometimes you have transactions that don't involve that. Somebody's selling intellectual property rights to computer software or whatever it is, or a franchise where there is no building, franchise rights. In those situations, there's no coverage under the individual policies for business brokering. It is only going to cover a claim against the actual real estate portion of the business opportunity. With regard to agent owned is a really complicated, much more encompassing thing than it sounds like. It sounds like a single concept, but agent owned is sale of your own primary, sale of investment, sale of commercial, renting your own property, flipping, buying properties, and sale of property constructed or developed by a related entity. Those are all the components of agent owned. When you get individual agent coverage, you only have coverage for the sale of your own residential, not commercial, not land, not renting, not construction development, not flipping where you did rehab work, sale of agent owned where it was your primary residence or something that you didn't renovate. So it's important to be aware that that's the only coverage you have. And if you want something different, I would say call an insurance broker who specializes in this stuff and knows what they're doing. Because again, the policies vary pretty dramatically.
And there is other policies. Paul's talking about individual policies. He actually specializes in group policies for brokerage firms that have policies over the top of everybody. But there are other carriers out there. There's other insurance brokers out there. Just make sure you're reviewing your policies to understand exactly what you're getting. I know the state program is 100, 300 as far as limits. Paul, you want to talk a little bit about what you think of $100,000 per claim limit?
Yeah, I think it's grossly insufficient. I would never do that. For my company, I carry $2 million for PBI Group. So I would never recommend anything less than a $1 million limit, which is why I'm a big proponent of what I sell, which is the firm coverage. I cover the entity and all agents, brokers, and independent contractors working on behalf of that entity. And so you get much broader coverage and much higher limits. So $1 million for me is what I consider to be the minimum of what anybody should carry. It's a personal choice, but that's my experience of looking at claims all day for a living has scared me enough that I think that's the appropriate limit. You have any opinion, Damian, on what the right limit is?
For the guys carrying individual policies where it's just for them, at a minimum, I would get the 250, 500. But I mean, it also depends on how much business you're doing and what kind of market you're in. If you're in a luxury market like Aspen and you do all sorts of transactions up there, that's probably not adequate either. I would say $1 million is probably the minimum for you as well. But so gauge your risk as far as what you're doing. And I think the biggest thing to take from this is that understand what your coverage includes as far as those policies are concerned, because if it doesn't include it, then you got to ask yourself if it's worth doing that transaction or being involved with that transaction and whether or not it should be referred out.
I would agree.
We had a couple more questions. Robert said that a common error seen on MLS listings is the listing agent indicates that the property is not subject to a metro district when in fact it actually is. Is there coverage for that?
Sure.
I will tell you that one is, there might be coverage if it's a misrepresentation. However, there's another. If I was defending that, what I would say is, well, buyer, you got a copy of the tax certificate. Tax certificate disclosed the metro district that was in place. So you actually did have knowledge about it before you closed the transaction. You could have walked away. You could have terminated your agreement. You could have said, hey, this was misrepresented to me, but you chose to move forward. So while there certainly might be coverage, there's defenses to it. Like I said, E&O likes to take premiums and deny claims. So I'm not sure how much risk there is with that one, but I'll let Paul talk about coverage and what that might possibly look like.
Yeah, I mean, look, the insurance industry has earned their reputation well, as used car salesmen have, but there's still some people who are in those industries that take a lot of pride in making sure that, you actually, if you get denied a claim, it's because you should have been denied a claim. So, but there's, point well taken that the industry has earned its reputation for a reason.
You're going to pick on lawyers. I'm going to pick on you. That's the way it goes.
No, but there are, I mean, on my program, claims don't get denied unless they call me and they say, I'm going to deny this claim. Are you okay with denying it? And so they don't get to issue a denial without that. And in the case of Damian's clients, he gets to know about it too before anybody issues a denial, and we get a say in that. But the idea is get the best coverage you can possibly get, so you don't have to worry about this stuff as long as it's within your budget. This particular line of insurance of real estate, is a complicated line, entrusted in people that really know what they're doing. This is not one to play around with because lawsuits are insane. I think it's 1 in 900 transactions statistically results in a lawsuit. The average lawsuit is $30,000. NAR did a 10-year study on the average cost of E&O claims. So 1 in 900 transactions is going to cost $30,000, whether you were right or wrong. And the vast majority of things that I see that come in as claims, the agent or broker did not make a mistake. The vast majority. This is not people screwing up and being careless with their job. This is a buyer who wants a free renovation of their kitchen, and they know that their attorney can get it by suing an insurance company that's more likely to settle than to pay $25,000 for a day in court to fight it. That's the reality. So get really good coverage so you have that coverage for the $25,000 day in court if you need to take it. It's just not something I would skimp on, and I feel strongly about E&O being a very specialized area of coverage. So did I answer your question, Damian?
I think you answered it. I think you're very passionate about your profession. That's what I think.
Yeah.
Go ahead, honey.
Okay, some more questions. So Joan mentioned that a rattlesnake showed up at her listing for an agent's showing. The seller was there and killed the rattlesnake. Could something like that have come back on her or her seller if something had happened?
Sure. Under individual E&O policies, no, you don't have any coverage for that. That would most likely be a bodily injury claim or a mental anguish and emotional distress claim. I'm trying to think where that could go.
Mental anguish is a tough claim. So yeah.
Yeah, but mental anguish and emotional distress, I think most people aren't even aware of this, is under bodily injury in E&O policies. So if you don't have bodily injury coverage, you don't have mental anguish and emotional distress. So for example, if you evicted somebody, and I had a claim a few years ago where somebody evicted a family a couple weeks before Christmas, and it was a rightful eviction, but they claim mental anguish, emotional distress because they're sitting on the sidewalk as Christmas approaches with their kids. That claim gets denied unless you have bodily injury property damage coverage. It's to say nothing of the merits of the claim, but the coverage for the claim gets denied if you don't have bodily injury property damage, because that's where mental anguish and emotional distress lives in these policies.
Now, I'll tell you on that one, because it's on the, there's premises liability statute that covers, that says, hey, if you own property, then you are responsible for injuries that occur on your property, depending on whether the person's an invitee, a guest, a trespasser, et cetera. So in that case, likely it would be the seller's insurance that would be first, and then potentially the broker's insurance if they had the bodily injury under a lockbox claim or something along those lines, I believe. Right, Paul?
If they can allege that the injury happened as a result of your failure in the performance of real estate professional services, and you have a good policy that has bodily injury property damage coverage, then yes, it's covered.
But it would still be the seller's policy first.
Yeah, probably.
Yeah.
Homeowners or.
Yeah. Go ahead, honey.
Okay, Rick asked, does E&O cover us representing buyers of new construction with builders?
Yes.
That does not require any additional endorsement or anything else.
Right. The construction development is only when you have an ownership interest or your spouse does with the builder or developer. It is not for third-party builders. You can represent third-party builders all day long. It has no coverage considerations with my policy or the individual policies. It's only when you have a relationship or somebody in your office has a relationship.
Okay, Catherine asked, if an agent gets a letter from a client's attorney, but no lawsuit is filed, notice is given to the insurance company, is this considered a claim which will cause a rate increase?
Yes, it's considered a claim. Anything you report to the insurance carrier is considered a claim. Claim does not mean lawsuit. It means a matter that you've reported to the E&O seeking potential coverage. Could your E&O go up as a result of a claim? Absolutely. It depends on the merits of the claim and how much it costs. If you report something that winds up as being a notice only and it closes for no pay, 99.9% of the time, it will have zero impact on your E&O. If you report something that develops into a lawsuit that costs $100,000, you're going to get an increase. That's if you have what I sell, which is firm coverage. On the state program, the individual policies, the pricing is locked in regardless of your claim history. But in exchange, you don't get a lot of coverage. So.
Teresa asks, do you recommend agents that only do their own rentals, so not property management for other people, get the property management endorsement?
So
I'm not sure that's going to have coverage either way, is it, Paul?
yeah, that's what I was going to say. I don't believe that the individual policies cover rental or leasing of owned properties. A broad policy like the one that I do, you would be covered for that. And my recommendation is always to my brokerage clients, make sure your agents are doing these rentals through the company so that there's coverage. If you do them on your own outside of the company, then you wouldn't have any coverage. So that's my recommendation, is make sure you get a good policy that has that. If you're unsure about it and you have an individual policy, call Rice or Williams or Crest or whoever and ask them, is there coverage for me renting out or leasing my own properties? And do it through the brokerage whenever possible.
Most of them are just not going to cover it. There's problems with running stuff through the brokerage firm in Colorado, because then you got all sorts of accounting problems with escrow accounts and funds that the brokerage firm would be responsible for and different things. So assume that property management of your own properties is just not covered, period.
Paul, a couple people asked what the average E&O claim payout is. I think you mentioned the NARV study that said $30,000. Is that kind of what you see as well?
That's the average claim. Yep, that's legal and damages.
Okay, so Robert asks, at the beginning of this Zoom, you indicated there's been a higher number of claims, in part due to, one, buyers making hasty decisions to make an offer, 2, multiple offers, 3, lack of research. He's looking for examples of how these issues can result in E&O claims. So what's causing this big increase in claims that you're seeing?
What's causing it is selling a house in 12 hours with 20 offers and no contingency and no inspection. It's like back in 2009, 2010, everybody thought, well, as is means as is. So if there's something wrong, you bought it as is. What are you going to do? That's not how it works. When you sell it as is and there's something wrong that somebody says you should have known about as an expert, you're still getting sued. It's sort of like going to a hotel and you go to the gym and there's signs on the wall that says work out at your own risk. Well, if there's a piece of broken machinery and you get hurt, there's a 100% chance you're going to sue and win. I don't care how many signs are on the wall. You can't disclose away negligence. So when you're closing a deal so quickly with so many offers, mistakes get made. You don't have time to investigate everything that needs to be investigated. I can tell you, my mom just sold her house this past week and the buyer didn't even go to the house. Out of state, just bought it. And then she showed up this Saturday to look at it finally. Well, that's not a good recipe. If there was damage, somebody is going to say, you are a professional realtor. You should have seen that black spot on the wall. That's mold. That's your job. You had to disclose that to me. I don't care if I'm out of state. I was relying on you as my agent to tell me these things. So you can't disclose away so the liability of negligence. And I think that's a big mistake that people are making. But that is the primary thing that I'm seeing is causing claims. Is it's happening too fast. You're not getting inspections. You're not getting contingencies. And there winds up being a problem.
And we've talked about that before, where the seller and the listing brokers think it's fantastic that the buyer's not going to do an inspection. That's a liability, not only for the listing broker, it's also a liability for the seller, because you've now taken away the buyer's right to inspect, the right to terminate based on the fact if they didn't like the condition. So of course the claim afterwards is going to be, well, we didn't even have a right to inspect. We didn't even have a right to look at the property. And what I see a lot of is that buyers get buyer's remorse. And in a market that was so fast and furious, like it was during the pandemic, they expected the property to be perfect. That's what they were looking for, is to say, hey, this property should be perfect. It should work and then they get in there and all of a sudden it's, oh my gosh, the neighbor is selling the property for less. And oh, there's a street behind my house that I didn't realize. And they get buyer's remorse and they're trying to claw back what they believe they overpaid for it, particularly when you had escalation clauses and appraisal gap guarantees and all this other stuff. Buyers hired lawyers to claw back what they believe they overpaid for property. And that was going to naturally mean that buyer brokers and listing brokers were going to be named in it.
Yeah. I think that's totally right. I think people paying the highest value, they know that the prices are totally overvalued. They're feeling bad about the transaction before they sign it. So it's causing people to look for remedies for how they get out of spending all this money or to get some of it back to do renovations that they want to do. Again, most of this stuff is not warranted. It's not, with cause, but it doesn't mean you can't allege it. And it's very easy to allege somebody committed a wrongful act when it comes to professional service. The standard on you is extremely high. I think most people don't realize that your professional service, I liken it to a doctor who pulls over on the side of the road to administer CPR on somebody. It doesn't matter if that person was their patient. They could still be sued for medical malpractice. Damian, I'm getting into your lane here. You disagree with me. When you're a professional realtor, you have an obligation to act in that capacity, to do all these things. Even if it's not sitting in the contract, you can still be held or at least sued for that liability. So I don't know if you want to add.
No, I agree entirely with what you're saying. We got one more question, and I don't know if you can answer this or not, but I'm going to say so. So the question is, who can an agent go to see what shortages you have under your E&O policy? Because a lot of them say they don't know what could happen, and they don't know what questions to ask. Which I think, and obviously, maybe it's not you because of the policies you sell may not be ideal for people that have individual policies. But could you give an idea as to who they should call or talk to when they're renewing their policies?
Yeah, I mean, there's really only two options. If you're going to a firm policy provider like me, you call a guy like me, an insurance broker who specializes in real estate, and ask the question. Otherwise, you call up Rice or Williams or Crest. Those are the three individual agent providers out there. And you ask them the questions and put it on them. And then make your notes and put it in writing what they told you. I don't know any other. I mean, I guess you go to a guy like Damian and have an attorney review it who knows real estate law and understands it. I don't know other options.
Yeah, I would go, and I mean, you can usually tell also by the endorsements that are available. At least that if there's an endorsement available for it, it means that there's no coverage in the base policy. Otherwise, they wouldn't be offering it as an endorsement. So that's one clue as to what to look for. I'm trying to think. In Colorado, we got Rice and Williams, which are both CNA policies, I believe. I think Williams has an add-on benefit to that policy. I think Crest is in the market here. Do you know of any other individual policies that are available in Colorado at this point, Paul? Or
that's it, just those three.
Okay. Here's another question. Risk reduction for listing agent. Have the seller perform a pre-listing home inspection and provide this report as a listing attachment. I will tell you, I like pre-listing inspections as long as the listing broker is not using it as a tool to prevent the buyer from having their own inspections. I mean, the minute that you guys are precluding the buyer from having inspections, you have to expect that you're going to get claims. I mean, that's just a recipe for disaster for the seller as well as for yourself. But frankly, having a seller do a pre-inspection and giving it to the buyer shows that the seller was serious about disclosing everything that's wrong with the property. So it's definitely, in my opinion, it's very helpful. And here's another question. Keith Alba asks, is Paul expecting an E&O company to stop writing E&O companies in Colorado after this year? Or expecting any E&O companies? We talked about this last year. There was a bunch of them that stopped, right? You had Hartford that got out, and
yeah, I haven't heard of anybody who's seriously in it, who's stepping away. I
At
expect
this point?
I expect the state program is probably going to have a pretty sizable increase in 2025. That's when their contract renews. But I haven't heard of anybody big getting out. There's only a few people that play in the state of Colorado. So,
Okay,
not-
great. Did you have other stuff you wanted to cover, Paul? I know Jill disappeared. Apparently her internet is not doing well. So she's at home and we live where the internet is not always good. So you don't get the advantage of your PowerPoint, but do you have anything else you'd like to discuss?
No, nothing I can think of. I had one, but it went out of my head. I was going to ask you a question. Do you want to, I usually talk about with the seller property condition disclosure specifically with the water related issues, that I encourage people to sort of give sellers a reminder of the types of things that may have happened. I can tell you in my space, most of my clients don't remember they had lawsuits. In the E&O, we look at the last 5 years of claims. Most of my clients don't even remember claims that they've had. I don't expect every seller to remember that they had some water damage 5 years ago. So in my opinion, I think it's helpful, since that's the most common claim there could be, to at least convey to the seller. I want to let you know the most common claim in real estate is that you didn't advise previous water damage. So, is there anything you want to tell me about? Did you have blowers in your house? Did you have a 5-year sideways rain? Did your dishwasher leak all over the floor? If you had your floorboards replaced, did you have your drywall replaced? I would probably bring up those things. I don't know, Damian, if that you think that's too much investigation.
Well, I'll tell you, I mean, what you're asking about is the seller's property disclosure and what advice should a broker give. And I think this is more than just water. That may be the one that you see a lot of, but for me, there's a bunch of stuff in that seller's property disclosure that sellers need to be aware of. And my opinion on the seller's property disclosure, we've heard a lot of, I don't know where the information comes from, but there's been a lot of information out there about, a broker should never touch it and they should never do anything with it. They should just send it to the seller. It's the seller's form and the seller should fill it out. And my opinion is a little different. I don't expect you to go investigate the house looking for stuff that the seller should put in the seller's property disclosure. That's not your job. That's not what you're supposed to do. You're not an inspector. However, I do think as a real estate broker, as a good real estate broker that's trying to keep their seller from getting sued about future claims that could come up or that the buyer could come back on them, I would go through the seller's property disclosure. I would talk to them about, hey, look, there's different standards by which you're supposed to answer these different provisions. Is this ever existing or now existing? Two different standards within the seller's property disclosure. And I would go through and tell them, make sure you answer this completely and fully and make sure that you're putting in everything that you can, because keep in mind, whatever you say to the buyer today is something they can't hold against you tomorrow. And that's really the point of that seller's property disclosure, is to give that information to the buyer so that they can't come back later and say, the seller never told me this. I don't mind you asking them questions about, I don't mind you guys asking questions about the, sorry, I had somebody pop in with something that they sent just to me, which may have been an investigator, but what she's saying is that all real estate brokers should do that. So hear that from the investigators, guys. But the point is that your job is to help your sellers protect themselves. So help them understand, if water is the most important claim out there, or the one that we get a lot of, say, we've heard that there's a lot of claims on flooding and it happens and you may or may not remember. So take some time to think about whether or not you did have a dishwasher or something along those lines, and make sure you fill this out completely so that the buyer doesn't come back later and blame you for something that wasn't that you tried to hide it from them. It's that you forgot. But when they find out about it, they're going to think you hid it from them. And I think that's a good conversation with sellers when it comes to disclosure.
And the seller can be sued for not disclosing that stuff.
Absolutely. And then, of course, they'll assume that the realtor knew about it too, because that's always where it goes. And we get out of those a lot because it's like, I'm sure you can't prove that. But at the same time, make sure that you are having that conversation. And guys, it's a good thing to have the conversation on the phone, talk to them, walk them through the form, but follow up with an email. about, hey, it was great talking to you today about the seller's property disclosures we discussed. Please make sure you fill it out completely. If you have a question about whether you should disclose something, this is me typing in case anybody's wondering what I'm doing here, but if you have any question about whether you should disclose something or not, err on the side of disclosure. Nobody's ever been sued for disclosing too much, but that will help you guys with your claims too, because you get dragged in when the seller doesn't tell something. And at least that way you'll have an email or something showing that you gave the advice that they should have told everything that they know.
I have two more quick things. I don't know if there's still time.
Yeah, we got time.
Okay. So I get asked the question a lot of whether or not there is individual excess available for those who want higher limits than what the state or the individual policies are willing to offer, or even those on a firm policy like mine. If somebody individually wants to get, a $2 million limit because they're selling an expensive property, or they personally want to protect themselves on a higher limit. I am not aware of any such product in the insurance market. So I'm just telling you this because I don't have a solution, but I get asked the question a lot. So I don't know of any available policies that will individually cover you on an excess basis. You might talk to your homeowners, whoever does your homeowners insurance for you, and see if there's any kind of personal rider that you can add. And then the other thing is a question I really have for Damian. So I get asked about team LLCs a lot. So as far as I know, team LLCs are set up on the back end for tax purposes to collect commissions, and that's really it. You are not providing real estate professional services through your team LLC. You're providing them through the brokerage under which you hang your license. But I get a lot of people who ask me, well, I have this legal entity. What if they sue my legal entity? What do I do? I don't know what the answer is to that. I don't know, Damian, if you have any thoughts on it.
Well, they're going to get sued, and that's just the way it is. Usually your coverage will still provide coverage for that. But you guys, the reason your entities get sued is because you hold them out to the public. I mean, you're not allowed to even do that. The real estate commission is very clear that you have to advertise in the name of a licensed individual, Paul, which goes back to what you were talking about with teams. You could say the Paul Bondy group or the, Excited group or whatever you want, as long as it's for licensed people. But what happens is you end up putting your entity name on it, and that's why they get sued, and they do not have insurance, and they're not licensed. So they can't have insurance. So my suggestion is keep away from those entities being anywhere out in public that anybody can see that they exist. And frankly, there's a lot of attorneys that give brokers advice about creating an entity to limit liability. It is impossible in our licensing structure. So you can't use your entity to limit it unless you're going to become a brokerage firm. Paul, there was another question here that I think I would like to ask, and I answered it already, I answered my thoughts on it, but I want yours. The question was, if I retire, how long should I keep a tail? Can you talk about the percentage of claims and when they come up and tail policies?
Yeah, so 90% of all claims happen within 1 year of the transaction. And then almost the next 10% happens within 2 years. And then you have fluke cases. I think Damian, you and I had one that was like 10 years or something. It was past the statute. Somehow the claim is going on. For me, I'd say 3 years is what makes me feel comfortable. It's up to you how long you will feel comfortable being covered after transaction close date. But actuarially, statistically, you can get rid of 99% of your exposure after 2 years.
And a follow-up question on that is, what's the statute of limitations? Well, the statute of limitations, guys, is 3 years. But the problem is the statute of limitations can be told, or it doesn't start until you discover the claim. So the one that Paul was talking about with the 10 years, what they claimed is that we didn't know we had a claim until we went to sell the property. And at that time realized that our broker had screwed up and then brought the claim at that time. So the statute of limitations is nice, but it's not an end all be all, because there's ways to say that it's told, or that there's a longer time to make that claim.
Isn't there a different statute for contract law and fair housing discrimination and bodily injury?
Contract is 3, torts is 2. I think there's different ones for fair housing, but I don't remember what they are off the top of my head. But yeah, I use 3 as the guideline just because 3 is usually the longest that you have as far as statute of limitations.
I think on the individual providers, I think they only give you 2 years. I don't think there's an option for anything beyond that. So I think if you have an individual policy and you want more than 2 years, you should call Rice or Williams or Crest, but I think you can just buy a policy every year until you're tired of paying for a policy and avoid it that way.
One more question. Or did you have something else you want to talk about, Paul, before I go to this question? Or
Nope, it's just those two things I brought up.
okay. E&O claims regarding agents involved in a transaction while outside area of expertise. So this is geographic competency. Example, agent from the city involved in a transaction in the mountains, perhaps lacking knowledge in short-term rental requirements and limitations. Is there coverage, I guess, is the question here.
There's coverage. It's why I don't like co-brokering, especially co-brokering out of area. I don't like the idea that somebody who's not familiar with the area being involved in the transaction. So I'm totally against the co-brokering idea.
Well,
but yeah,
I think I like co-brokering when you're going to co-broker with somebody in the area that has the expertise to help advise the client versus you doing when you don't.
Well, I can see good and bad. I don't like the idea that if I own a brokerage, that one of my agents could be held responsible for the mistakes of the management of somebody at another brokerage. That's always my concern.
Right.
But yeah, bringing in a specialist is always good. But I worry.
It probably depends on how that's set up. But, you guys should be cautious about what he's saying is be cautious about taking on the liabilities of somebody that doesn't know what they're doing. So don't co-broker with an idiot. I guess that probably isn't that's legal jargon in case you guys are wondering, but.
Yeah, there should be coverage for that. I don't see any reason why out of area has any impact on coverage. Now, with the individual state program, you have what's called conformity. You can only sell in Colorado. You can't sell in bordering states and have coverage unless you buy the conformity endorsement.
Right. I think that covers it, honey. I think we're right at 3.
Perfect. Any other questions out there?
And you made it back.
I did. Internet crapped out there for a few minutes. No idea. And then a bolt of lightning sounded like it hit our house right when I signed on. Out in the Wild West here. Let's see. There was in chat here concerns with the Colorado Real Estate Commission investigations beyond the statute of limitations.
Oh yeah, they aren't subject to the statute of limitations. So anytime you have a claim, a real estate commission complaint, it doesn't matter when it happens. They can investigate those for as long as they want. So there is that.
Yeah, and let me tell you, on Monday this week, one of my clients submitted a claim because she got a disciplinary proceeding complaint, hired an attorney to defend her, and then turned in the claim for the carrier to pay the attorney bills that she paid to defend herself. That's not covered. So we talked about that earlier. You can't have a claim and then bring it to and pay for it and then ask the carrier to pay for it. You have to have the carrier appoint the defense for you. And one of the things I talked about in the very first thing I was saying with what you should report is there is defense in E&O for disciplinary proceedings, for complaints brought through DORA. So you should utilize that coverage and get an attorney to represent you so that it doesn't lead to a future lawsuit.
Great.
Terrific.
Want to wrap it up, honey?
Right. Yeah. Before you all sign off, I want you to save the dates for our upcoming updates. So our next update is going to be on September 7th. That's our landlord tenant update with Pete Muccio. October 5th, Scott Peterson is going to be doing a legal update on behalf of CAR. November 2nd, Damian will be back on talking about all the contract changes that are going to be happening in 2024. There are quite a few, so that'll be a quick high-level overview of those. And then December 7th, we're going to have another title talk with Terry. Terry Williams is our VP of underwriting here at Heritage Title. And that was a really popular session last year as well. So save the dates. Thank you so much for joining us, Paul. As always, thank you. This is always such a great session, so informative. We really appreciate you and your time. Thank you for being on today.
Sure thing. Bye, everybody.
All right.
Bye.
See
Thanks,
y'all
Paul.
later. Bye.
Bye.